Welcome to Literary and Jury Charge Practice. Let's get started with our Cinderella story. Ready? As I examined and opened the box, I started seeing familiar logos on the package and leaflets promoting the company's newest professional writer at the time. I just thought they were advertising their newest and best to the lowly student, but then I was able to see it. I was receiving the full-blown professional writer. I screamed as loud as a teenager in a boy band stadium. As a tech nerd, I secretly had my heart set on this particular model when I graduated school, but now I was holding it in my hands, bright, shiny, and new. I felt like I was given the keys to a Formula One car and was told to go racing. All right, now for some jury charge. The subject of this jury charge is punitive damages. Ready? Members of the jury, if you find that the plaintiff was unlawfully evicted and obliged to leave the premises without notice by reasons of the wrongful acts of the defendant, then you may consider whether or not, under all the circumstances, the plaintiff is entitled to recover what are known as punitive damages. Such damages are by way of punishment, that is, to punish the wrongdoer for his wrongful and unlawful acts, and keep him from committing like offenses in the future. You may take all the facts and circumstances into consideration and then award such an amount for punitive damages as you feel would be fair and just under the circumstances. Punitive damages are allowed only when one does an act wrongfully and maliciously. in the contemplation of the law, where one interferes with the rights of another knowingly and purposely, if at the same time he knows it is wrong and unlawful, then it is malicious. Punitive damages should not be excessive and should be reasonable. They should be fitted to all the facts and circumstances in the case. All right, let's go over some of the words that may have been a little challenging. We had punitive damages, wrongdoer, maliciously. We had malicious and maliciously. So good words maybe to give a little extra practice. All right, let's get back to our Cinderella story. I think we're almost to the end. Ready? To top it all off, Dan then explained that he called my school to find out which theory I was using so that he was able to pick the correct keypad setup for my writer. After I got everything working the way I wanted it to, I was passing tests and flying through the next few speed levels faster than I ever thought I could. I never thought in a million years that I would have a fairy tale moment like this. I got to experience the joy of seeing my pumpkin, in this case the avocado, turn into a sleek, brilliant steno chariot, all thanks to my boyfriend. It gives me great pleasure to inform you that 7 years later, I graduated court reporting school, passed my tests, got my California state license, and celebrated my second wedding anniversary with Dan. I feel comfortable saying that he and I are both living happily ever after. Nice Cinderella story. I thought that there might be a word in here that we might want to give some extra practice. Maybe not. But we did have fairy tale, a fairy tale moment. Oh, chariot. So she got to experience the joy of seeing her pumpkin turn into a sleek, brilliant steno chariot. Steno chariot. I like that. All right, let's get back to some jury charge practice. Ready? It rests entirely with you whether or not you should award any such damages. If you do, they should be fair and reasonable. The jury are the sole judges of the facts in the case. The credibility of the witnesses and the weight to be given to their testimony in anything that the court may have said throughout the trial, or anything that the court may say in the instructions. The court has not intended and does not now intend to express any opinion upon the facts of the case, upon the credibility of the witnesses, or the weight to be given to their testimony. Furthermore, the court instructs the jury that you have a right to consider all the evidence in the light of your own observation and experience in the affairs of life. Another lit here, and it's called Finding Motivation. Ready? And it's actually by Tiva Wood, and this is in our NCRA magazine, and she is currently NCRA's president. Ready? Finding motivation. This fall, I went hiking with my sister in the Daniel Boone National Forest located in Kentucky. We planned ahead and mapped out the trails. We wanted to take to reach Gray's Arch, one of the most spectacular arches in the Red River Gorge area. After hiking 4 miles over somewhat difficult trails and not finding the arch, we returned to the car to eat lunch. At that point, we saw another trail that indicated the arch was 1.2 miles ahead. My sense of motivation kicked in. Yes, we were tired. It was hot, and we were somewhat skeptical because the other mapped trails had not gotten us where we wanted to go. But there was no way I was going back to Pennsylvania without seeing Gray's Arch. Grit and determination took over and motivated us to hike a few more miles to accomplish our mission. All right, this jury charge is titled Scope of Employment. Ready? Ladies and gentlemen, it is the law of this state that whenever a motor vehicle is operated upon any street or highway of this state by any person other than the owner with the consent of the owner, express or implied, the operator thereof shall, in case of accident, be deemed the agent of the owner of such vehicle in the operation thereof. Therefore, the operation of a vehicle on a public highway by one who is not the owner creates and justifies an inference that the vehicle is being used for the owner and with his authority until and unless such inference is overcome by other evidence. Deviation from the regular course of duty does not necessarily take the employee out of the scope of his employment. If the employee combines his own business with that of his employer and is attending to both at the same time, then he is still within the scope of his employment. The test of liability of the employer is whether at the time of the accident the employee was performing some act in furtherance of his employer's business as well as in his own interest. All right, some words to practice. Let's see, we have inference, deviation, furtherance. All right, that will conclude our literary and jury charge practice.